Hi, I'm Rick Denser. Welcome to the Post Connect to Family Model Training Module, Paternity Establishment and Child Support. I'm so happy you're here. Hopefully, by the end of this training, all of your questions will be answered. Maybe, maybe you know quite a bit about how paternity is established in Ohio. Maybe you know all the things, or maybe you don't know much at all. It's okay. If you still have questions after this training, I do have my contact information listed on the last slide. I hope to answer everything though during this training. Let's go ahead and dive in. First, we're going to start with the legal relationship as it's defined in the Ohio Revised Code. The parent and child relationship extends equally to all children and all parents, regardless of the marital status of the parents. How is that establishment of the parent and child relationship done legally? Well, for a mother, she gives birth. A father establishes. And an adoptive parent shows proof of adoption. That's how it's laid out in the Ohio Revised Code. So what does paternity actually mean? Well, it means legal fatherhood. In Ohio, if the parents are not married to each other when the child is born or within 300 days, I'll say more on that later, that child does not have a legal father. Paternity must be established to create a legal relationship between a father and child before the father's name can appear on the birth certificate. In Ohio, we have two categories of paternity establishment. The first is presumption of paternity. The second is final and enforceable establishment of paternity. This is specifically for Ohio. If a child is born in another state and they come to Ohio, Ohio child support offices will request the birth certificate from that other state. As we're going to learn the rules for how paternity is established in Ohio, other states may have different rules, and that's okay. Even if paternity is established in another state in a way that isn't required in Ohio or isn't a part of our procedures, Ohio will recognize their paternity by giving what's called full faith and credit. So, what is the difference between presumption of paternity and final and enforceable establishment of paternity? Let's find out. Presumption of paternity, uh, here are the ways that that is established. The first, if the parents are married and a child was born during the marriage. Presumption of paternity means just that. It's that a man is presumed to be the father. Right? So if parents were married and a child is born within 300 days of the marriage dissolving, that also counts as presumption of paternity. But I do want to point out here that date is based on the legal dissolution of the marriage. It can take up to 2 years in Ohio for divorce or dissolution to become finalized as recognized by the court. So the date that the parents break up or end their relationship or separate, it's not that date legally in Ohio. It's the date that it becomes finalized in the court of law. Lastly, a father signed the acknowledgement of paternity, but 60 days have not yet passed because a rescission can occur within those first 60 days. I may call that an AOP going forward. I do want to acknowledge here, often when people say he signed the birth certificate, what they're actually talking about is this, the acknowledgement of paternity form. Once all parties have signed that, that starts the clock on the 60 days. For the first 60 days, that's considered presumption of paternity. After 60 days have passed and there's not been a rescission, then it flips to final and enforceable determination of paternity. I supervised paternity establishment and support order establishment at child support in the past. There are various reasons why someone may want to rescind that initial acknowledgement of paternity. In my experience, maybe the father was there at the hospital and then may have doubts whether he's actually the father for whatever reason. If that's the case, he can go rescind, or their mother could rescind, technically request the rescission, and then the parties will be tested genetically. There will be DNA and genetic testing at that point. The other ways of final and enforceable determination of paternity in Ohio, by a judgment order or court judgment entry or court order. This is usually a divorce or a dissolution. There is another way, which I will talk about later. But once that becomes finalized, that is technically a court order. And if paternity has not been established up until that point, um, other than the presumption of paternity, it becomes final and enforceable when that marriage is legally dissolved. And then the third way is by an administrative order. And this is completed by child support enforcement agencies after genetic testing results have been received. I do want to point out here, this says CSEA. Several slides say that, which stands for, as I just mentioned, Child Support Enforcement Agency. But not all county child support offices go by Child Support Enforcement Agency. Some call themselves Office of Child Support Office, Bureau of Child Support. There's various acronyms or names, but I am referring to child support offices when I say that. So these are the ways of establishing final and enforceable determination of paternity. But what does that mean for the parents? Well, you'll notice here and on multiple slides, I have the Ohio Revised Code listed, the number. That's for your reference. If you would like to look up the full code, read the full language, have more context, I provide them here in case you would like to do that. The one we're going to talk about now is 311.26, the effects of final and enforceable acknowledgement. There are three main things when it comes to once paternity is final and enforceable. The first I'm going to talk about is that a legal father may file a complaint requesting a parenting time order. If parents are unmarried, the mother is under no legal obligation to allow parenting time between her child and a father. Let that sink in. A father does not have rights until legal paternity is established to request parenting time. But it goes beyond just the dad. Once paternity is established, the father and any relative of the father may request companionship or visitation rights with the child. It does not mean that they will get granted, but they can legally request them, and a court can set those guidelines for companionship or visitation rights. And then also the legal father assumes parental duty of support. And we're talking financial duty, and we will talk about what that means as far as a support order here in just a little bit. I'm going to talk about something that happens actually quite often. I had no idea how often this happened until I worked at child support. But what happens if a mother is married to one man but names another man as the father, or another man believes he's the father? Well, I have the ORC code right there for you, 311.74, acknowledgement conflicting with presumption of paternity. If two parents are married and they never legally sever the marriage, they never legally dissolve the marriage in court, and the wife births a child, her husband is the presumed legal father. So he is the legal father under presumption of paternity. So what happens? If that happens, if a mother is still married, gives birth at the hospital shall not allow the alleged father to sign the AOP. So even if mom and the man who believes he's the biological father is there. He's there for the birth. Even if both mom and dad say, hey, this is the guy, if she's still married to somebody else, that other guy is the presumed legal father, and the hospital will not allow anyone else to sign the AOP. And this counts even if legally separated. It's until the judgment entry that the marriage is legally dissolved. Um, what happens then in that case? What well, if a woman's married to another man but believes this man is the father of the child, child support can test. We'll swab the mother, we'll swab the baby, and we'll swab her husband, and he could then be excluded as the father. Some child support offices, if this is the case and everybody's at the hospital, if your local child support office does go to the hospital to do genetic testing, some will test the alleged father right there, and if he comes back as the father, that automatically excludes the husband, but they would have to be tested. They can't sign the AOP. When you're in doubt or you don't know, call the CPR, Central Paternity Registry. That's for Ohio. They can verify if paternity has been established for any child born in Ohio. I do want to plug here. It is very important we verify paternity has been established. We have been told before that paternity has been established only to find out months later it never legally actually was established. And that's what we're talking about, the legal establishment of paternity, because quite a few things change once that happens. I am leaving the phone number on the screen for an extended amount of time, so you have it. Obviously, you can look it up after this training as well. There may be folks that signed something in the hospital. It does not mean they signed the acknowledgement of paternity. All right, so if paternity has not been established and we've verified this through some other way other than asking family members, what do we do? What are the options? Well, let's talk through them. There are I would say three main options. The first is having all the parties sign the AOP, right? The acknowledgement of paternity affidavit, it is a JFS form. There's the number for you right there. I'm going to have more on each of these. I'm going to go in a little bit more depth. The second way is genetic testing, right? After genetic testing is done, child support will establish via an administrative order. More about this in a moment. The third way is a judgment entry or court order, as I mentioned, but there is a caveat with that one that we will talk about. But first, let's talk about the AOP. Yeah, you know me. Naughty by nature joke there. Both parents must sign the AOP, the acknowledgement of paternity. They do not have to sign at the same time. They don't have to be present. If they don't get along, that's okay. They can sign it at different times. It must be notarized. So I will say, at the end of the day, it needs to be filed with the child support office. It doesn't necessarily have to be done there, although that's the easiest. I would encourage folks just to go down to child support. It is the most efficient way to expedite the process if we are establishing paternity through the signing of this affidavit. Again, folks can go down to the office at different times. They can all go down together. It doesn't matter. Child support office will have a notary republic. Once both parents have signed, it is sent off. And again, it's presumption for those first 60 days, and then it flips over to final and enforceable determination of paternity. Signing is the quickest and easiest way. Now we're going to talk about more specifics regarding DNA or genetic testing. I will say that this can be requested by anybody if final and enforceable determination of paternity has not yet been established. Any man believing himself to be the father can request a paternity test. Um, Even if there's a presumed father in one of those categories, mother can still request DNA testing to verify. I will say these are free at local child support offices at any time. Um, with a caveat, there could be they may not be free under one condition. I'll talk about that on the next slide. But if final and enforceable determination of paternity has not been established, again, it's free, and anyone can go down to the child support office and request it. I will say it would be good to call your local child support office and find out their testing hours. Some only have walk-in appointments or walk-in hours one day a month. Some have it one day a week. Some have it any day of the week, any week. It just depends. Obviously, there are scheduled appointments. That's how most of them happen. Most of the genetic tests happen at scheduled appointments, but those can sometimes be weeks or months out, depending. So if a child support office does have walk-in hours, I encourage you to find out because that could be a way to expedite the process. The other thing to find out is where tests can happen. The county I was in, we went to the hospital, we would go to court, we would go to jail. We could test off site. Not every child support office has that ability. Some can only test at their office. So it's good after this training to contact your local office and find out more. Then there's the caveat of when a court order is required for the DNA and genetic testing. Well, the first, as I mentioned, is when a final and enforceable determination of paternity already exists. I will say that if a man believes or a mother believes that someone else is actually the biological father, and one of those other ways have already been done under final enforceable, it will require a court order and it will not be free. It will be the cost of the person requesting it at that point. Another time where a court order may be required is if a mother is refusing to cooperate or if her location is unknown. One of the weird things about Ohio law is that the mother has to be swabbed. Even though we're not establishing maternity, right? Mother gives birth to a child, her legal relationship is already established. But her DNA is required to establish paternity. So if one of these things exists, the court can order a motherless draw. Child support cannot request the test until there's a court order for the motherless draw piece of it. It could be a part of another motion as well. And I just also want to note that at-home DNA tests do not legally establish paternity in Ohio. Even if that is presented in court, uh, almost always the judge or magistrate will request the genetic testing be done by child support because they need to prove the chain of custody. So once all parties have been swabbed, then the results get shipped off um, to DDC DNA Diagnostic Center in Fairfield, Ohio. They are the lab that run every child support paternity test. There's a statewide contract. Usually, child support get these back in 2 to 3 weeks, sometimes less, sometimes more, but um, usually. I do want to point out that there may be a DNA swab already on file. That can also help expedite things. If a mother has already been swabbed, she can just sign a waiver. They don't need to swab her again. Even if a dad was swabbed under a previous child, he can also sign a waiver. It does get a little tricky if he doesn't sign the waiver. Um, and child support offices do have to get uh, they have to get service of process under Civil Rule 4 in Ohio, which I will talk about next. The third, we talked about a judgment entry or court order, and I acknowledge that the vast majority of these are done when a divorce becomes final in the court in Ohio. It is extremely rare, but judges can order someone to be the father of a child without genetic testing and without the AOP being signed. This usually only happens, well, it doesn't usually happen. If it does happen, it's usually only after child support office can prove the father was legally served notice of the paternity appointment multiple times and failed to show to those scheduled appointments. It's another important thing to distinguish here that mother or father may fail to show for scheduled appointments. It doesn't mean anything unless child support can prove that they were legally served. And I will tell you from experience, child support offices go to great lengths to meet that civil rule uh, process, civil rule 4, to officially serve folks. Because if someone never knows that there was a paternity appointment or a genetic testing appointment and they don't show up, that's not their fault, right? So there are different rules. You can look it up. It is certified mail signature, served in person. So some child support offices, we had a deputy that we had a contract with that would go out and serve people. And again, we would have to show that we served this person multiple times, show that proof, and only then. Even then, though, there are still things and steps that can be taken. So I just want to say that that is an option. Now I'm going to talk about child support offices. Um, what they do, whether they are part of a children's services case or not. Child support offices are there, and it's more than just enforcing support, right? So we're going to talk about it. Child support offices, they actually have something called paternity only services. Either parent can request this if paternity has not been established. Um, and essentially, folks would come in, get tested, and then once the results come back, paternity is legally established and child support closes this case. There's no support order attached. It's just paternity only. But of course, they do establish and enforce support orders as well. Um, this happens all the time, right? Again, whether PCSA is involved or not. And I do want to point out that any parent, any custodial parent, can request child support from the other. Um, and it does happen while folks are still married, usually as a part of some legal proceeding. But if they're not married, it can be requested at any time as well. Um, once PCSAs have custody of a child, CSCAs they're required to establish paternity. Obviously, if it's not been established, to reimburse foster care maintenance monies. And then there's a child support order set as a part of every divorce or dissolution of marriage. Caveat to this, though, this can be set to zero. It's called a zero support order. So maybe the parents have something worked out. Maybe there's, custody is shared evenly. Um, but either way, it's required that a support order is on file. So it is possible to have a $0 support order. So essentially, child support never enforces anything. They never collect money. They never get that money to the custodial parent, but one is on file as legally required. And a caveat, if a parent is receiving cash assistance um, and a child comes into custody, that could be offset with a child support order as well. But yes, they do establish and enforce support orders, and that's probably what most people know them for. Now I'm going to talk very briefly about the Putative Father Registry. I'm sure most of you know what this is, but just a refresher. It's a computerized database maintained by the Ohio Department of Job and Family Services. This allows a male to register if he believes he may have fathered a child and wants to be notified if that child is ever placed for adoption. The caveat is he needs to register on the putative father registry within 15 days after the child's birth. This registry is should be searched to determine, whether a child, when they're going through that, going to be legally adopted, um, or if a child is placed for adoption. Um, the putative father should be notified and can then seek legal counsel regarding his rights if he would like um, to be considered at that point. Why should someone register? Um, Well, if he does not register and it's within those 15 days, the child could be legally adopted without his knowledge or consent or without him having any rights in the process. I will say, um, any man who thinks he may be the father of an unborn child, so that's another caveat, or within 15 days of the child's birth, should register. Once 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 they are registered, they are on there forever. This does include fathers who are minors. If they're not 18 years old, they can still register on the putative father registry. And they can anyone can register as many times as they would like. It's only once per child. But if a man believes he's the father of many children, he can register once per every child essentially. And I'm going to leave this next slide on the screen a little bit longer just so you have it. I know you could look it up, but there are several ways to register on the Putative Father Registry. You can find the application there at that link. Um, you can print out a form. You can send it in the mail. You can call and request a form. But there it is. Okay, one last thought before we end our time together. Once a man is deceased, paternity can still be established for a child that he fathered. And it's, I believe it's very important to do this. What happens, whatever county the man passed away in, that county coroner is required to take a DNA profile. The length of time that they keep that profile on record varies. It varies by county in Ohio, let alone by state. So some keep it on file forever, some keep it up to 2 years. It just depends. We have established from this way in the past that it requires a court order. We get that DNA profile from that county coroner, and then that sample is tested, and that's how it's done. It legally establishes paternity in Ohio, and then from there, that child could then they could be entitled to an estate, but if they don't have that, it could be like from the father or even a relative of the father potentially. How vague the language is if someone else is deceased, uh, but there could be financial considerations for that child. And even beyond an estate or something like that, there are Social Security or survivor benefits that could assist in supporting the child. Again, once paternity is legally established, and then obviously the value reasons behind our work. Um, the family history, the cultural history, the heritage, the family stories, and opening up a whole half of a family tree, right? For a child, and then the option to connect to those relatives. Medical history. There's lots of reasons for legally establishing paternity. So I just wanted to let you know that there are options out there, even if the man is deceased. All right, that is our time together. If you have any questions, please reach out by email, by phone. Happy to talk through any scenarios with you or answer any questions.